My name is Robert Metz, and I'm the author of the just published book entitled Real Estate Prosperity. My book is available in both e-form and hard copy at www.realestateprosperityllc.com. This is the second in a series of podcasts dealing with profiting by speculating, flipping, long-term investing, and rehabbing foreclosure properties. There are many, many ways to profit in foreclosure properties, but as I stressed in the first podcast on foreclosures, knowledge, prudence, perseverance, and a game plan, a method are crucial to succeed. Our first podcast on foreclosures, we left off with the point of the lender, who is a plaintiff in a lawsuit, obtaining his final judgment in foreclosure against the defendant, the borrower in default. Even though the jurisdictions of states differ in terms of their procedures, there are many common threads in all of the states, and the bottom line is that the final judgment of foreclosure sets the stage to enable the lender, the foreclosing lender, to proceed to what is commonly known as a foreclosure sale, the ultimate step in the conclusion of the action. Now, the essential elements in all of the jurisdictions to go to the sale is that the foreclosing lender, or more properly the attorney for the foreclosing lender, submits certain paperwork, certain documents, typically to the sheriff of the county in which a property is located, or to some other official in the jurisdiction that handles real estate, that handles foreclosure actions in the area where the property is located. It does not have to be a sheriff, it can be some other court official, depending on the state rules. The attorney for the lender will submit a copy of the final judgment. He will submit a proposed order, the figures with the breakdown as to everything that is owed, a copy of the ad, a proposed advertisement copy for the sheriff to place in the required local newspapers to advertise a sale in accordance with the local statutes, to provide public notice, and the theory being the most opportunity for a sincere, legitimate bid on the property. And the foreclosing lender's attorney also has to provide a deposit for the sheriff's fee, or the fee for the other appropriate official who's handling the sales in that jurisdiction, and also for the various costs, the advertising, etc., that the official places to promote and set the sale. Until the sale is actually called, literally until the last minute, the parties, defaulting borrower and foreclosing lender, can work to solve the situation. The lender can let the borrower still reinstate the loan, modify the loan, do a straight or short sale of the property to pay the loan off, or some portion of the loan that's mutually agreeable. The borrower can try to refinance, sometimes a foregone conclusion that that's not possible. And other resolutions are possible. A deed in lieu of the foreclosure, by which the defaulting borrower conveys the property for additional consideration or not to the foreclosing lender. And sometimes there's mediation as an opportunity to try to bring the parties together and bail the thing out, so to speak, at the 11th hour. Now, also prior to any sale, there's a variety of delays, even if the foreclosing lender opposes them, which are at the disposal of the defaulting borrower. The delays are partly statutory, meaning by court or state rules or laws. There are a variety of maneuvers that can contribute to delay to hold a foreclosure sale off, whether the defaulting borrower is about to try to cure the debt or just wants to hold matters. And there's various other things that could be done. Sometimes a constitutional, a procedural challenge to the final judgment, to the setting, the particulars of the foreclosure sale. Sometimes a defaulting borrower can come in with an order to show cause, hardship delays to gain more time. The defaulting borrower can file a Chapter 13 for an individual, Chapter 11 for an LLC or corporation, to either try to reorganize the debt typically over a 3 to 5 year period, or just as a delayed mechanism to gain perhaps 1 to 2, 3 to 4 months or more, and depending on the situation, possibly have the option to refile the bankruptcy when he gets dismissed, even if he does not make any payments on a bankruptcy plan. So bankruptcy, again, can be used either as a delay tactic or as a means to a permanent cure. The Chapter 13, the Chapter 11 can be filed at the last minute, literally the last second, even over the objections of the foreclosing lender. Now, once a sale is scheduled and held, or about to be held, there are very important things to bear in mind. Number one, the stereotypical sale on the steps of the courthouse. Typically, it's almost like an old southern courthouse, big, steep, concrete steps, is certainly not the norm. Typically, the foreclosure sales are business-like meetings or gatherings, usually in a large room or even a smaller office room, depending on the size of the attendance and the number of properties on the docket within the courthouse. Again, it is usually the sheriff or other appointed, designated judicial official who handles a sale. Most foreclosure sales, which are auctions, are what is called reserve auctions. Reserve auctions mean that the party putting the property up for bid, in this case the official, the sheriff, acting as and through the foreclosing lender, sets a minimum bid. And if the minimum bid is not met in the bidding process, then the party who put the property up for sale has the ability to cancel the sale, to withdraw the property, and go back to point zero, either reschedule the sale or do whatever the parties may agree to, or whatever legal strategies are available for the foreclosing lender to pursue. Aside from a reserve auction, which is a norm, there's what's called the absolute auction, which means any bid, the highest bid takes it. And sometimes in an absolute auction, the bids can be well under market value. But again, most foreclosure auction sales are in the form of a reserve auction. Bidders, third-party bidders, have to be very careful at a sale. It is not the simple process that some portray a sheriff's sale to be. There's a lot to it, in plain English. The bidder has to be aware of superior liens which may not be named in the foreclosure documents or the sale that they saw in the legal advertisement section of the newspaper. They have to know what other clouds obligations are on title. For example, if the first mortgage is for $100,000 and the property is worth $150,000 and the first mortgage is foreclosing and there's an IRS lien for $200,000 sitting on the property, the IRS lien, or some other tax lien, for example, would typically not have been named in the sale notice. So a bidder goes to sale, he says, here's a property worth $200,000, I can get it for $140,000, $120,000, $160,000, whatever, good deal. What if there's another $200,000 lien there? He can bid that money, be obligated to pay that money, or default on a deposit that he gives at the sheriff's sale if he backs out. And whether he defaults on the deal when he finds out of the superior lien and loses his deposit from the sale, or if he never finds out or still follows through on the deal, to pay $140,000 or $160,000 for a $200,000 property that has another $200,000 in debt on the property that you're going to be absolutely saddled with is not exactly a winning proposition. It's obviously a gross and a net loss. So the bidder at a sheriff's sale has to be aware and careful to look for superior liens. He has to do his due diligence. He has to do some homework, inquire, have a professional run a title search, get some information. Now, there can also be other obligations on the property, other encumbrances, other than monetary ones. Now, where the lender takes a property back, let's say in a reserve auction where the upset bid, the minimum bid was not met, or if he withdraws it in an absolute auction, where the lender takes the property back, The lender, instead of getting cash out of the sheriff's auction sale, the lender gets a property. And again, depending on the equity situation, LTV, loan-to-value ratio, how much equity there is in a property, the lender's intentions, the lender's resources, and a whole variety of factors, it may or may not make sense for a lender to take the property back. Many times properties are taken back by lenders in reserve auctions where the minimum bid price is close to the value of the property, and there's a huge encumbrance, where the encumbrance is either greater than the fair market value of the property or very close to the fair market value of the property. On a $200,000 property with an encumbrance of $195,000 or an upset bid of say $180,000, there's not a lot of sense in a third party bidding on it unless there's some other reason other than a spec or long-term investment that the prospective bidder is looking at. Maybe he needs that property to piece together another tract. Maybe he needs that property because it's a key location for his retail store or for a gas station site. So unless there's a factor like that where the property lends itself to a unique or a customized use, or there's a customized or unique desire for the property by the bidder, if the upset bid, if the debt is too close to the fair market value, there's not enough equity in it. It's not a sensible deal with the risks involved and the transaction costs for a bidder to pay almost fair market value for a property at sheriff's sale, and then encounter the other variables, unknowns, expenses, and delays that can be incident to taking title and clearing the property out. Now, where there's a winning third-party bidder, typically, most jurisdictions require the bidder to post a 30% cash or cash equivalent deposit at the time of sale in order to have his bid stick. If he does not post the deposit, or if he fails to come up with the entire deposit immediately after the sale, after indicating that he has it, well then the property would go to the next highest bidder. There being no other next highest bidder, so to speak, either the lender can take the property back, or typically he might withdraw it and relist the property at a subsequent sale for auction. So having posted his 30% deposit successfully, the winning bidder then has to wait out what is called a redemption period. In New Jersey and a lot of jurisdictions, the redemption period is typically 10 calendar days, meaning that from the date of the sale, the borrower, who is now in limbo, he's still the borrower and the owner because there's a 10-day redemption period before the sheriff's sale auction is actually effective. The borrower still has the opportunity to cure the entire debt to the lender. If the borrower can come up with all of the money before the 10-day redemption period is over and the lender accepts it as he has to, the sale gets canceled and any third-party bidder gets his deposit back, less his nuisance and transaction costs. The sale is canceled. Title remains in the name of the defaulting borrower, who at the 11th hour, within the 10-day redemption period, voided the sale and bailed himself out. Foreclosing lender gets his money. Game over. Very unusual that situations like that occur, although I could tell you from personal experience, I've been involved in, I guess, several classic type redemption period successes whereby a typically unknowledgeable borrower in default who let the sale go and then was notified of the redemption period came to his senses, or had somebody bring him to his senses and said, hey, you still have a lot of equity in this property. Let's make a deal. Let's pay your lender off. Kill the sale before the 10 days are over. Keep the property. Live in there. Let's flip the property. Let's rehab it. Let's do something with it to turn the negative into a positive, and let's make some money with it.